Did you know that you can downgrade your I-140 petition based on an approved labor certification from EB2 to EB3? Why would you do that? A lot to unpack today, so let's get at it. All right, so let's talk about downgrading an I-140 from EB2 to EB3 and why on earth you would do that, right? So a lot of times what's happening is, particularly for Indian nationals and Chinese and even other foreign nationals, what happens is you can only file your adjustment of status employment-based petition when your priority date is current or when the filing chart becomes current for your petition. I've done an extensive video on the visa bulletin. I would recommend that you go there right away, get the tutorial on that, and then continue with this video, okay? Particularly this month, for example. Let's look at the January 2024 visa bulletin. China. China, in the last 6 months, has not been current. It has been far from current. We had some interesting movement in January of 2024. If you look, they are processing petitions in the EB3 category that have been approved for July of 2021. That is a significant move, folks. So if you have a petition in the EB2 category that's approved, that's not current, you want to downgrade that petition to the EB3 category. How do you do this? You could do it one of two ways. The first way you can do it is you can file a new I-140 based on your approved labor certification in the EB3 category. You can premium process it, get the approval in 15 days. You can also concurrently file that I-140 petition with an I-485. So you can lock in that priority date. Let's say you have a currently pending I-485 in the EB2 category. You can request that I-140 be transferred to an EB3 category, okay? I put a link here in the description box below. You go to USCIS, it tells you exactly how to do it, where to file it, etc. You want to keep in mind on this visa bulletin, sometimes, hey, you have to downgrade to be able to get your case to the finish line. Alrighty, we got some really good news that's upcoming on I-751 petitions. There's new guidance in the policy manual. This is the manual where immigration makes policy. You can learn a lot by going to the manual and find out what immigration's policies are and changes. So as you know, an I-751 is a petition to remove the conditional status through marriage. It's called an I-751 petition, right? Initially, you get the conditional resident status for 2 years. At the end of 2 years, you have to file this I-751. There's several ways you can file the I-751, joint and separate, okay? So a lot of times what's happening now, folks, it is taking 4 years to have an I-751 adjudicated. So let's say when you filed, you were still together in marriage, everything was good. Let's say in the second year, the U.S. citizen spouse starts abusing the conditional resident spouse, things change, they separate, and now they're getting a divorce. So you have the 751 that's pending. How do you change it to a waiver? It's called a waiver. So on a separate petition, you can file several ways. You can file a waiver to remove the conditional status and prove that the marriage was valid, just terminated in good faith, or based on abuse. That's where you have extreme cruelty that was perpetrated upon the conditional resident spouse. So there hasn't really been guidance on how you change from one petition to the other petition. Generally, with my clients, once it gets to the interview stage, I let the officer know that we're changing this to a different status. Sometimes, depending on the case, I withdraw the joint petition and file a new waiver petition, okay? So there's several ways to do it, but finally, immigration is going to provide us with some serious guidance in the policy manual on how that is done. I look forward to seeing that, and I'm going to share that information with you as soon as it comes out. I put a link in the description box below here that takes you to the USCIS website, talks about the policy changes, when they're happening and when they're going to come. So stay tuned. All right, really good news. A federal judge finally made law. It is unlawful to separate children from their parents at the border. You remember I talked about this years ago, Trump's zero tolerance policy. They were taking kids from their parents. It was abhorrent. It was horrible. A lawsuit was filed back in 2018. This lawsuit finally has come to fruition after 5 years, and there is a final finding and a ruling in a settlement that it is absolutely unlawful for ICE and CBP to separate children from their parents at the border. That is fantastic news, folks. You know, that's always been one that's dear to my heart. Keep the kids with their family. Remove them together, it doesn't matter, but don't separate them. That's way too cruel. All right, I got something really interesting that's coming up. I'm gonna do a whole video on online accounts. You want to get an online account these days with USCIS so you can track your case, you can get your RFEs quickly. I'm gonna do a whole tutorial on how that's happening, how the attorney also has an online account, and how we can coordinate together to best facilitate the streamline of your case. Thanks so much for watching GrayLaw TV. Click below, like and subscribe. See that subscribe button? Hit it, boom, watch it blow up. Great stuff, folks, and I have tons of content in my library. Go to it, check it out. Good stuff. You can learn a lot about immigration law for free. Thanks again, and we'll see you next time.